Everything that you need to know about lead-based paint disclosure forms in this video. Hey everyone, my name is Paul Vacheski and welcome to the Randall School of Real Estate YouTube channel. Real quick, give this video a thumbs up and hit that subscribe button, click that notification bell. All right, in today's video, we're going to discuss what you as a student need to know about the lead-based paint disclosure form, because no doubt you're probably going to have a question or two on your real estate licensing exam. So let's jump over to the computer and I'll show you everything you need to know. All right, so let's move into the lead-based paint disclosure and the things in this law that you need to know so you can pass your real estate licensing exam. Now, first of all, before we move on with this video, you might want to go down to this comment section of this video here and please print these three reference materials. There is the lead-based paint disclosure for the lessor and the lessee, which is the landlord-tenant one. The other one is the lead-based paint disclosure for the buyer and the seller. And then the third one is protect your family from lead in your home. It's an EPA pamphlet that we're going to be referencing. And we're going to be talking about the latest version, which is 2020. And understand the EPA does update this periodically, but as of the time of this video being recorded, it's 2020. All right, Lead-Based Paint Hazard Reduction Act. That's the federal law that was passed in 1992, and it's plain and simple why it was passed. Lead poisoning is real and it's detrimental, in particularly to children and those mothers that are pregnant with children. Now, it can also have adverse consequences on adults as well, but children really are the ones that take the brunt of the poisoning. And any house that's built prior to 1978, some houses can be loaded with it. So, under the law, sellers have specific requirements that they have to comply with. Agents have specific requirements that they have to comply with. Buyers have certain options. Landlords have certain specific requirements. Everybody that has to do with housing, residentially zoned housing, has obligations and duties to perform, and we're going to talk about those in this video. So let's get right to it. The law applies to, first of all, any property that's residentially zoned that was built prior to 1978. It does not include 1978. So any home built 1977 or earlier that's residentially zoned must comply. The law requires sellers and landlords and property managers, if there's a management contract in place, to provide a lead-based paint disclosure to buyers or tenants. Now, here is a copy of what one of those disclosures look like. And this one here is the buyer and seller one, but don't forget there's also one specifically for the landlord and the tenant. And you cannot use these disclosure forms interchangeably. So if it's a landlord-tenant relationship, you have to use the lessor-lessee lead-based paint disclosure. If it's a buyer-seller relationship, then you have to use the buyer-seller lead-based paint form. It's substantial civil penalty if you use the wrong form. All right, so the form must be provided to the buyer or the tenant prior to the buyer or the tenant entering into a contract. So in the case of the sales side of it, the lead-based paint disclosure needs to be executed by the buyers prior to the purchase agreement being signed. Very important. Now, under the regulation, the disclosure is considered addendum number 1 to the purchase contract or addendum number 1 to the lease agreement. This is one area where most people don't realize that, not even seasoned real estate professionals. A couple of things that the landlord and the seller must disclose in writing. They must disclose the physical location of any known lead hazards on the property, and that disclosure is typically made on the lead-based paint disclosure itself. Now, if there are reports or documents or test results regarding the location or any test results or documentation regarding anything to do with lead-based paint, copies of those documents or reports must also, in addition to the lead-based paint disclosure, be given to the tenant or the buyer. It's not uncommon in many parts of the country where you have the one sheet that's the lead-based paint disclosure, and you could literally have hundreds of pages of associated documents or reports about lead-based paint related material. And this is important to understand. It's not just limited to any kind of document or report that tests positive or is an affirmation of the lead in the home. Even if you have a test that's done and it shows that there was no lead-based paint, those documents also have to be provided to a tenant or a buyer. Any document whatsoever related to lead-based paint regarding that particular house has to be given to any future tenant or buyer. And it's perpetual, meaning this goes on, the requirement goes on indefinitely. There are no statute of limitations to it. Landlord or sellers must provide the buyer and tenant with the EPA's pamphlet called Protect Your Family from Lead in Your Home. Very important that you don't miss this step. And in fact, on the lead-based paint disclosure itself, as you can see on your screen, there is a section where an acknowledgement has to be made by the tenant or the buyer that they've received that pamphlet. So the pamphlet, Protect Your Family from Lead in Your Home, needs to be given to those buyers or those tenants. Now, sellers must provide a buyer also with a 10-day opportunity to have a lead assessment done, meaning they have to give the buyer the opportunity to have a lead test done. Now, this same opportunity does not belong to the tenant. The tenant does not have that right, but the buyer does. And here's the thing. The seller cannot say no to this. Now, the buyer and the seller can negotiate a different time frame. They could negotiate a 7-day or a 12-day or a 14-day. But if the buyer and seller cannot agree on a negotiated alternative time frame, then it defaults back to the 10-day. So if the buyer wants to have an assessment done, they have the right to do it, and the seller cannot say no. They cannot accept, what they can't do is not accept a purchase contract because the buyer has asked for that opportunity to have a lead assessment done. Now, there is one caveat. If there is multiple offers, meaning more than one offer has the buyer requesting the opportunity to have the lead assessment and another one without the assessment, then the seller can take the one without. But if it's just one offer and the buyer has asked for the assessment, then the seller must allow it. And it is a buyer cost. The buyer is responsible to pay for those assessments or those tests. Now, all the agents involved in the transaction must inform the seller and or the landlord of their legal obligation under this federal law. And let's take a look at the disclosure form on your screen. There is a section there where the agents must do two things. They must initial, and then they must also sign down below, all the agents involved. The same applies to property managers. So what is the seller's responsibility? Well, as we talked about, the seller is required to provide the lead-based paint disclosure. They're required to provide any known location, physical location of any lead hazards. And they also are responsible to provide any kind of documentation, such as reports and those type of things related to lead-based paint, whether there was lead-based paint that was detected or not. Again, those negative test results must still be provided to a tenant or a buyer. That is the seller or the landlord's obligation. And as agents, we have an obligation under the law to inform them of that obligation. Now, one thing I want to point out here, it's kind of interesting. Typically, it will be the property manager, or in the case on the sales side, the listing agent, that's going to initial that saying, hey, landlord, or hey, seller, here's your obligations. But let's say that it's a for sale by owner transaction where the buyer's agent, a licensed buyer's agent, is taking their buyer to a for sale by owner. And the for sale by owner has not completed the lead-based paint disclosure. Then the responsibility would fall on that buyer's agent to inform the seller of their obligation under the federal law, and then they would initial in the agent section on. And then last but not least, all buyers and sellers, all agents involved in the transaction must sign the document as well. Very important to remember that. All right, so here's another video you might want to check out as you continue with your studies for your real estate license. And right over here, that little circle, if you have not subscribed to this channel yet, I would appreciate you doing that. We'll see you in the next video.